Thank you, Madam Deputy President. It's NIDOC week, and this is the first time I've risen to speak this week, so I'm just going to take a brief opportunity to acknowledge the Palawa Pakana of Lutruwita, Tasmania, the traditional owners and ongoing custodians of this land, the land that was never ceded. I acknowledge the Muanina people, originally of this place, Nipaluna, Hobart. I acknowledge the elders past, present and emerging of the Tasmanian Aboriginal community. NAIDOC Week is an important time to celebrate the rich and vibrant culture of the Palawa Pakana, whose connection to this land extends back beyond 40,000 years and has survived invasion and dispossession. Thank you. Thank you. Now, to the bill. Madam Deputy President, I welcome this bill and its progress in improving Tasmania's indefinite detention laws. This is well overdue, as our current laws have been recognised for some time to have deficiencies which have rendered them less effective in delivering safety to the community and less able to provide appropriate justice to offenders. I acknowledge the work that's been done by the government and those in the department to bring this bill to fruition. Consultation has been undertaken quite extensively across a range of stakeholders on the development of the bill, and I note that we are even today likely to make amendments to the bill brought by the government and based on further feedback from the Chief Justice of the Supreme Court provided after the passage of the bill through the other place. In discussing this bill, I think it's helpful to remind ourselves of some foundational tenets of criminal justice. I think it's important to remind ourselves because there are instances in which this bill supports those foundational tenets, and there are instances in which this bill is intentionally setting some of them aside. And it's no small matter to set aside a basic concept of justice, so it's important that we do so not lightly, but with careful consideration, and especially in regards to balance and proportionality. I think it's important to remind ourselves of some key foundational tenets of criminal justice, and I'd highlight just a couple here. One being that a person is innocent until proven guilty, and that's otherwise known as the presumption of innocence. Another being that the onus of proof rests with the prosecution, and the prosecution has to establish the guilt of a person. A third one that's really important is that a person should not be punished more than once for the same offence. That's sometimes referred to as the double jeopardy rule. And additionally, I'd note a couple of further foundational principles, such as that a person should not be punished for something that they might do, but only for something that they have done. I'd acknowledge a principle around incarceration that incarceration in its essence infringes upon fundamental human rights to liberty, and the deprivation of liberty is only justified by a finding of criminal guilt. That the ultimate purpose of punishment through imprisonment is to rehabilitate the offender, and that the civil liberties we enjoy as citizens of Australia and as residents of Tasmania should only be curtailed in circumstances where it is absolutely necessary to do so. I'd like us to bear those foundations in mind when we look at this bill. And the bill itself deals with the matter, as we are aware, of indefinite detention. That is, situations in which a person is deemed to be a serious danger to the community and can be further detained or otherwise supervised and monitored beyond the conclusion of their original custodial sentence. We can immediately see that this is squarely in opposition, if you like, to some of those fundamental principles, including the principle that a person should not be punished for something they might do, but only for something they have done, and that incarceration infringes upon fundamental human rights, and the deprivation of that liberty is only justified by a finding of criminal guilt. Further, I think the important one there is also that the ultimate purpose of punishment through imprisonment is to rehabilitate. So we're prompted to be careful and intentional in our consideration of justice in relation to the matters in this bill. We know that the High Court of Australia has acknowledged the legality of indefinite detention in exceptional circumstances. However, even with this fact established at the level of the High Court, as we know, the devil is in the detail, and it's our job to be considering and scrutinising the detail here. And we must do that with an awareness that it relates to exercising a power that fundamentally transgresses some of our core concepts and principles of justice. It's my view that this makes it incumbent on us to construct a framework for that power that has two things. A framework that has the least infringement on the personal and civil liberties of our citizens, alongside the greatest degree of accountability on the state for exercising that extraordinary power. The arrangements that we have in our current laws do not get that balance right. I believe that they neither achieve the least infringement on liberties nor the greatest degree of accountability on the state, and hence we are all in agreement that they need to be improved and updated. And in fact, the 2017 Tasmanian Law Reform Institute research paper provides a very clear roadmap to reform and improve Tasmania's current indefinite detention laws in this respect. Madam Deputy President, that review found that courts currently are reluctant to make dangerous criminal declarations because of the substantial barriers to discharging those declarations. The review made a series of recommendations to improve current laws, including recommending periodic reviews be provided in the interests of justice and to safeguard against institutionalisation. And it also identified that, unlike other jurisdictions, here we had no capacity for courts to impose conditions pre or post release. Options were limited then for managing the risk of serious danger to the community in a more nuanced way. In responding to each of the recommendations in the TLRI paper, this bill improves the process of declaring and managing a person in custody whose potential for violence poses a high risk to the community. So, Madam Deputy President, the existing judicial reluctance to exercise the power of indefinite detention unless under exceptional circumstances is quite understandable due to the severity of that punishment it imposes on the individual and the need to weigh that against the degree of risk to community safety. However, given that the power exists, it is incumbent on the state to ensure that the processes involved are as functional and effective as possible. A clear problem with the current law was that only the sentencing judge could make a declaration, and that's presented difficulties in circumstances where the judge has ceased to hold office. Part 2 of this bill solves that problem and confirms when a declaration may be made, and that now includes a range of circumstances described in the leader's speech that now capture a range of opportunities for declarations to be made. That's appropriate, it is functional, and it is more effective. It brings Tasmania into alignment with some other jurisdictions by providing also a list of mandatory factors for the court to consider in determining whether to make a dangerous criminal declaration. It requires the court to consider a whole range of matters, including the nature and circumstances of the offender's criminal conduct involving violence, their antecedents, their age and character, the need to protect the community, any relevant psychiatric, psychological, medical or correctional reports, and the risk of the offender being a serious danger to the community if they're not imprisoned, as well as other matters the court considers relevant. That's quite considerable and expansive. That's now a requirement of the court to give consideration to. I think that's appropriate and a substantial step forward with this bill. And I note too alongside that the test for the court to apply in making a declaration and the standard of proof required have also been aligned with those of other jurisdictions and aligned with what we would regard to be an acceptable standard within our criminal justice system. Under this bill, that onus of proof has been put back onto the state rather than on the individual in question, as has been quite inappropriately the case under our current laws. I think this change and the improvements it brings aligns very well with the core principle that I mentioned earlier, which is around the prosecution, the onus on the prosecution to establish a person's guilt, rather than the person have to prove their innocence. Madam Deputy President, the bill also addresses a problem with the current laws identified in the TLRI review, that there is no periodic review of dangerous criminal declarations that have been made. The bill provides for that now, with regular opportunities for a declaration to be reviewed, occurring at 3-yearly intervals. Further, it provides for an offender themselves to apply for a review in exceptional circumstances of their own dangerous criminal declaration, and that's a very positive inclusion. There may well be cases in which the offender themselves has reason to request such a review, and that may well be in the interests of justice that they are now able to do so. Again, we have some clarity provided in a mandatory list of factors for the court to consider when conducting such reviews, and I think again that provides clarity and strengthens the framework and accountability that's there on the part of the state in exercising these powers. The factors that are there listed in that review process includes whether the risk posed by the offender may be appropriately mitigated by imposing a high-risk offender order on the offender, which is part of that new second-tier scheme. And the availability of this option removes some of the sense of all or nothing that existed under the current arrangements, where the court may have erred on the side of refusing to discharge a dangerous criminal declaration and keeping a person incarcerated beyond the time that they might otherwise have been able to have been, at least to some degree, at liberty. And what this means is that under the current laws, where it's difficult to remove the dangerous criminal declaration, what we now have is an opportunity to more readily and in a more nuanced way bring that to bear. The bill addresses this gap well and gives the court that power, certainly looking at the opportunity for pre-release orders during the review process or prior to discharging a dangerous criminal declaration brings that nuance further forward. That can be done either of the court's own motion or an application by the DPP or the offender. And again, I think that's an important inclusion into this bill that does actually tilt towards a sense of justice for all those involved, including the offender in question. Courts under this process can obtain information deemed necessary to assess that need or the benefit of the pre-release orders that they may consider. And that can include looking for information on availability and suitability of programs and activities that may assist with the offender's rehabilitation and reintegration into society. I think that's a very positive inclusion here. In some sense, I would almost hope that that potentially provides an opportunity for another level of advocacy to help us ensure that, in fact, offenders are given access to appropriate and effective services or programs or treatments while they're incarcerated, when it's known that courts will be reviewing and looking for information about the access for those things to people who fit into the categories covered by this bill. Madam Deputy President, under the current laws, an offender under a dangerous criminal declaration is either in prison or is released into the community unsupervised at the discharge of that declaration. And as already discussed, this can be problematic. It could result in people being kept incarcerated for longer than may be necessary, or released but without what may be considered an appropriate level of supervision and monitoring, neither of which are preferable. The new bill allows the Supreme Court to impose an HRO order as an alternative to renewing a dangerous criminal declaration. This is a very positive step forward. It's been referred to as a step-down usage, as it's a lighter punishment than being imprisoned entirely until the next review. If the conditions attached to the order are breached, the offender can face 2 years imprisonment, so there's an appropriate penalty available for breaches. The conditions described in the bill around these have been correctly, I think, described as intensive monitoring. They are quite substantial, both the mandated ones and the ones that are available as optional. The bill creates the HRO Assessment Committee comprised of government agency representatives, and they have a clear role to play preparing reports, coordinating agency responses and facilitating information sharing to advise on the management of the HRO orders. This committee is designed to reduce the case management workload of the DPP so that can better determine whether to apply for the extension of the HRO order. I think that's a really positive in terms of functionality and effectiveness, so again, a good inclusion in the bill. I have an amendment for a further explicit inclusion into the membership of the HRO Assessment Committee, which I'll speak to in the committee stage. And I also have an amendment in regards to matters that must be considered in determining whether to make an HRO order, which I will speak to later also. And now, Mr. President, I'll speak briefly about an HRO order in relation to the similarity and dissimilarity to parole, just to make explicit that distinction. The post-release conditions that are available under a high-risk offender order allow for that provisional release into the community, and in some ways with conditions that are similar to parole. But for clarity, unlike parole, those measures and conditions and constraints do extend beyond the custodial sentence that the person served. These people that we are looking at in this bill and in relation to these HRO orders have done the time for their crime, and this is additional to that time. So it's quite distinct from parole in that sense, which has a definite end date aligned to the sentence that the person was serving in prison. The basis for the post-release conditions under the HRO order is that there is a risk they'll commit a serious offence again, and it's designed to reduce recidivism and protect the community. These are people who are known to be prone to violence. They've demonstrated a propensity towards that. The risk is deemed to be high to the community, and so conditions are considered such that protection can be provided and the liberty of that person can be allowed to an extent that balances against the safety of the community. And while it's accepted that that's an important measure to have available in really exceptional circumstances, we must remember that the reason for that exceptionality is because it contravenes some of those basic principles of justice. And just as a reminder, it contravenes the fact that a person should not be punished for something that they might do, but only for something that they have done. It contravenes the fact that the ultimate purpose of punishment through imprisonment is to rehabilitate. And it goes against the fact that the civil liberties we enjoy as citizens should only be curtailed in circumstances where it's absolutely necessary to do so. And with that in mind, Mr President, I'd like to reflect on 3 specific areas of concern that I have in relation to the HRO orders components of this bill. And it's really just to put them as a matter of record here. The first of those concerns relates to the application of these orders beyond simply those who've been subject to a dangerous criminal declaration. The second reading speech tells us that there are some serious offenders who do not meet the threshold for being declared a dangerous criminal, warranting indefinite detention, but who nevertheless may pose an unacceptable risk of committing another serious offence if no supervising conditions are in place when they are released post-sentence. So, as well as that step-down usage for those whose dangerous criminal declarations are being discharged, HRO orders here are presented in the bill also to function as a step-up mechanism in some sense. That is, there's the ability to apply them to offenders who are not declared dangerous criminals but who are deemed to pose a risk of committing another serious offence if the HRO order is not imposed at the conclusion of their custodial sentence. I don't believe this circumstance was covered entirely in the TLRI review. I don't recall in that review reading an examination of that circumstance in detail, but I'm happy to be corrected if that was covered. And I think we're prompted to carefully consider here where that threshold is going to land in terms of who that could or may be applied to, those HRO orders. It gives me pause, Mr President, to consider that threshold, knowing that thresholds can move and shift. In the bill, it does say in section 32, subsection 2, that the Supreme Court may only make an HRO order in relation to an offender if the court is satisfied to a high degree of probability that the offender poses an unacceptable risk of committing another serious offence, unless an HRO order is made in relation to the offender. And then in subsection 3 of section 34, it also says the Supreme Court is not required to determine that it is more likely than not that an offender will commit a serious offence in order to be satisfied to a high degree of probability that the offender poses an unacceptable risk. So what this tells me, Mr President, is that we are anticipating that a person may come to the conclusion of their custodial sentence, the sentence the courts determined was appropriate for the crime they committed, and while not being regarded as warranting a dangerous criminal declaration to necessitate further imprisonment, they're deemed sufficiently dangerous to pose a high level of risk to the community. And in such a case, the first question that I would be prompted to ask is why we failed so catastrophically in our responsibilities as a state during their period of incarceration. Remembering that the ultimate purpose of punishment through imprisonment is to rehabilitate the offender, and that a person should not be punished more than once for the same offence. If someone concludes their custodial sentence such that they pose either the same high level of risk to the community as when they went into prison, or possibly presents an even higher level of risk than when they went in, then first and foremost, I believe that's an indictment on us as a state and on our criminal justice system. And I think instead of our response to this being, in the first instance and first instinct, the curtailing of the rights and liberties of that person through the imposition of onerous conditions and restrictions, I believe our first instinct should be to step up and ensure categorically that our prison system and broader criminal justice system is fit for purpose, is appropriately equipped to deliver on contemporary understandings of justice, and is able to produce positive outcomes for our whole community, including community safety. This is a failure of our system if people arrive at the end of their custodial sentence and are actually in a position to require this form of HRO order. Given this concern, I've not proposed an amendment that relates to it, as it's a matter of policy, and I would have needed further time and resources to consult appropriately and propose a possible solution to the concern, and perhaps there isn't one. However, the concern remains, and I believe it's given even more urgency by the recent custodial inspectors report here in this state, which highlighted such devastating failure within our prison system to best serve the interests of rehabilitation. And that failure not only doesn't deliver positive outcomes for prisoners and for the community, it's likely that we are actually seeing negative outcomes actively driven by the situations currently in our prison, a worsening of circumstances for some of those who spend time in our prisons, a higher likelihood that people will arrive at the end of their sentence in such a place that they will be subject potentially to these HRO orders. And that is not their individual failing or fault. I regard that as a systemic failing and fault of our system. And that, to me, Mr President, does not look like justice. And it has to be part of that consideration of accountability for the state balanced against the least imposition on personal liberties. Mr President, the second concern I have that I would like to highlight with around the HRO orders relates to the fact that they are potentially indefinite and permanent. The current bill that we have puts the maximum at 5 years per high-risk offender order. That's in Section 38, subsection 2A. But there is no cap on that order being renewed indefinitely. Now, it may be that those circumstances don't arise. It may be that, in practice, high-risk offender orders are imposed, and they may not even be imposed for the maximum of 5 years, but they may, in some circumstances, and certainly the bill provides for this, they may be put at the 5-year maximum, they may be reviewed and reapplied, reviewed and reapplied, and it could create a situation where, for example, an offender who has served their custodial sentence is no longer declared a dangerous criminal in the context of being kept incarcerated, but they could then have significant constraints on their civil liberties for an indefinite period of time, perhaps the rest of their life. And the punishment, if they breach one of the conditions, is fairly substantial. We know it can be up to 2 years, so there's quite a hefty penalty hanging over their heads. I have concerns about the potential indefinite nature of those orders. I don't believe that does represent consistency with some of the principles and purposes of criminal justice. Just particularly those principles around a person not being punished for something that they might do, but only for something they have done, and that the ultimate purpose of punishment and the constriction of civil liberties to this degree is punishment. The ultimate purpose of punishment should be to rehabilitate an offender. And I don't believe necessarily that just the outright imposition of these constraints in and of itself delivers rehabilitation to the offender. And again, Mr President, I haven't proposed an amendment in relation to this concern that I'm expressing here. I looked at a possible amendment that would have put an absolute time limit on any HRO order or sequence of HRO orders. perhaps a time limit that corresponded to the period of that person's original custodial sentence. But due to the complexity of that drafting and the need to give a more comprehensive consideration to framing it up, I haven't pursued that amendment. However, I'm registering the concern here, potentially for future discussion. The third and final concern I wanted to raise around the HRO orders in this bill is really around a matter of balance. What I see here with these orders is that all the constraint and conditions are put on the person, the individual, under the order, and none are put on the state, in my reading of this, effectively. Section 37(1), which are the things that must be included in those orders, and 37(2), which are things that may be included in terms of conditions and constraints, are extensive. The person can have almost every aspect of their life constrained in some way, their activities, their associations, their employment, the place they live, the things they consume even, as discussed in briefings. As a state, Mr President, we are placing such onerous constraints on the civil liberties of a person who has already served their time for the offence they committed, and we're doing so against a fundamental justice principle, the one that says a person shouldn't be punished for something they might do. And given that, I'm concerned that when I think about the balance here, that I don't see any legislative expectation or requirement that the support and the treatment and the rehabilitative needs of that person are to be met by the state. If we give ourselves the right to do this, that is, impose such onerous restrictions in these exceptional circumstances, where is the recognition, the explicit recognition and acceptance of the responsibilities that we as a state should bear to accompany that right to impose and exercise that power? I did have some comments from some lawyers around this, and I'll read one of them. It said, "The only comment I add is that some of my barrister colleagues in New South Wales, during a conversation I had regarding these laws, opined that similar laws operate in New South Wales and serve as a source of injustice. We would be better served with intensive post-release rehabilitation programs that focus on drug and alcohol abuse, life skills, education and employment. All of the evidence demonstrates rehabilitation deters and reduces offending. Draconian laws do not." And in a separate piece of communication from another legal colleague, "In terms of taxpayer funds, a much better use of resources would be intensive support, not monitoring." And I was interested to receive those comments because I think they align with what I'm trying to get at here, that we have all the legislative emphasis on constraint of the individual and no explicit accountability put on the state to deliver on the rehabilitative side of things that would be required and should be expected alongside the constraint. So how can we moderate in the service of justice the deprivation of civil liberties that occurs under high-risk offender orders in the pursuit of community safety? One way to ensure that we're not putting these onerous constraints on people in a manner that's simply set and forget is that we ensure we don't do that because we look at them more frequently. One of the things I'm suggesting in an amendment is that we set a maximum of only 3 years for the operational period, the maximum operational period of an HRO order. I'll speak more about that in the committee stage. But doing that means that we are not setting and forgetting. We are accepting that this is something we should be on the front foot about ensuring is appropriate and set at the right level. And in light of the fact that the order could well be on this person for the rest of their lives and that people's circumstances can change, I think it's reasonable to review the extent of an order at intervals of at most 3 years. I think that helps us balance this ledger here, where we as a state accept a level of responsibility to ensure that this power is being exercised appropriately. We know that the review of the order could result in conditions being removed or adjusted. It allows us as a state to be confident that we're exercising this extraordinary power as lightly as possible. Mr. President, in light of those three areas of concern that I've outlined there around the HRO orders, which were the application beyond the dangerous criminal declaration, the potential indefinite nature of them, and that there is what I perceive to be an imbalance between constraints put on the person and responsibilities accepted by the state, I would ask that the government make a commitment to a formal review of the application of this new Act within a timely interval to assess its functioning and impact. I would like to see that review undertaken by an independent body such as the TLRI, and I'd like that review, amongst other things, to give consideration to some of those specific concerns that I've raised here, and perhaps there'll be some others that are raised by other members. I'd be interested also, separately, to have an understanding from the government today around what it expects in relation to the numbers of Tasmanians who may come under the powers laid out in this bill. We know that the deficiencies and problems of the current laws have deterred, to some extent, their use by our courts. And so with the changes brought in by this bill, where we see some of those problems and deficiencies addressed, may we then expect to see greater usage of the dangerous criminal declarations, for example? And also, with the inclusion of the high-risk offender orders in this new bill and the benefits that that could bring, in some measure in terms of nuance and appropriateness, what level of use are we anticipating around those newly created HRO orders? I'm interested to know what the expectation is, and that would also be something I think would be useful to see reviewed and certainly reported on in coming times, so we can see what the impact may be of the new approach. And certainly, Mr. President, I would acknowledge that whatever the numbers are in terms of this new bill and its application, whether it be the dangerous criminal declarations or the HRO orders, I am absolutely in support of the improvement that this bill delivers, and it certainly delivers us confidence far beyond what we have currently, that these powers are being exercised in a more robust framework in the service of justice, and that this bill is a positive step forwards in regards to the indefinite detention arrangements in this state. It's just my intention to highlight that as good as this improvement is on what we have currently, it's important because of the nature of the extraordinary power that's present in this bill that we don't take our eyes off the impact that it has and the future ways that we might be able to assure ourselves of the appropriate balance between constraints on individuals and responsibilities and acceptance of responsibilities by government. So I thank the government for the work done on this bill, for the improvement that it offers, and I'm certainly in support of it in a broad sense.